The Second Amendment says the right to keep and bear arms shall not be infringed.
You say that crime went down, but did you know that the sales of the so-called assault weapons went up?
For years, the Democrats told us we're not coming for your guns. Oh, yes, they are.
To a member on the Democratic side that served in a combat area designated zone and deployment of our country.
In the Heller case, the Supreme Court made clear that the Second Amendment protects firearms in common use.
Oregon mag ban struck down. All right, buckle up for some legal drama from the wild world of Oregon. So you won't believe what just went down. Oregon's mag ban, that's Measure 114, just got slammed with a 1-2 punch and knocked out cold by a recent court ruling. Picture this. The court dropped the mic and declared Measure 114, that pesky mag ban, totally unconstitutional. And get this, they didn't just give it a slap on the wrist, they hit it with a permanent injunction, basically saying, you're out and you're never coming back. But wait, it gets better. Or worse if you're rooting for the ban. Despite the state of Oregon doing the legal equivalent of a Hail Mary to overturn the decision, they crashed and burned. Yup, their efforts went down the drain, and the court stuck to its guns, holding firm on the ruling that Measure 114 is about as constitutional as a rubber chicken in a courtroom. Now let's break it down. Measure 114 was all about putting the brakes on mags, not the glossy fashion kind, but the ones that go into firearms. They wanted to slap restrictions on the number of rounds these bad boys could hold, but the court, oh sweet justice, said, nah, that's not gonna fly. So what's the big deal? Well, this ruling means no more hoops to jump through if you want to grab a mag or two for your firearm. The court called a timeout on the state's attempt to make gun owners do the cha-cha with background checks, safety courses, and whatnot before they could get their hands on a mag. And just when you thought the show was over, the court dropped the mic again by making the ruling permanent. That means Measure 114 is toast. Gone. Kaput. It's like the court sent the ban packing and said, don't let the courtroom door hit you on the way out. Now, the state tried to pull a legal rabbit out of its hat, filing objections left and right to undo the ruling. But guess what? The court wasn't having it. They shut down every objection like a teacher shutting down excuses for not turning in homework. So in a nutshell, Oregon's mag ban is officially out of the game, declared unconstitutional, and slapped with a permanent injunction. The court said, you can't play here anymore. And that is how the legal cookie crumbled in the great state of Oregon.
They should be respected.
Reclaiming my time. So, Mr. Chairman, I'd like 40 seconds
I've seen my constituents die in battle.
Piece of legislation and voting on whether this nation is going to be all in on a new nuclear arms race.
Major legal victory. Permanent injunction against statewide mag ban. Hold on to your hats, folks, because the legal battlefield just witnessed a major showdown. And it's a victory dance for the gun owners of America. Let me break it down for you. We're talking about a legal smackdown in the Arnold versus Kotek lawsuit, and the GOA just pulled off a move that would make any legal thriller jealous. In this corner, we have Measure 114, Oregon's attempt to put the squeeze on mags. But guess who stepped into the ring to defend the Second Amendment like a superhero with a legal brief? That's right, the gun owners of America. So what went down? The court, like a referee in the ring, made a call that echoed through the legal universe. They dropped a shocker, a permanent injunction. That's legalese for slamming the brakes on Measure 114, preventing it from seeing the light of day. Imagine GOA as the underdog hero, taking on the mighty Goliath of anti-gun measures. The court didn't just say, hold on a sec, let's think about this. No, they put their foot down and said, no more Measure 114 shenanigans. It's out, and it's out for good. This victory isn't just a win. It's a declaration that the Second Amendment gets a front row seat in the legal arena. The GOA stood tall, and the court recognized their arguments, giving Measure 114 a knockout punch. Now, for those not fluent in legal jargon, a permanent injunction is like telling Measure 114, you're not invited to the party, and we don't want to see your face again. It's the legal equivalent of putting up a massive do not enter sign. And here's the kicker. Despite the state's desperate attempts to reverse the court's decision, it was a no-go. The judge didn't budge, and Measure 114 was left in the dust. Now let this be a victory lap for the defenders of the Second Amendment. GOA has shown that even in the legal ring, the little guy can land a knockout punch. Measure 114 tried to play hardball, but the court, with GOA in its corner, said, "Not on our watch." In the end, it's more than just a legal victory, it's a celebration of the right to bear arms. The gun owners of America have etched their name in the legal history books with this triumph, and Measure 114 is now just a distant memory in the rearview mirror of legal battles.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
This is a lever action. Under this bill, lever actions apparently are okay.
Judge rejects state's attempts. In this breaking news update, we've got the inside scoop on a judge who's not taking any nonsense from the state's attempts to do a legal U-turn on the mag ban decision. So here's the lowdown. The state of Oregon, probably armed with a suitcase full of legal arguments, tried to sweet-talk the judge into changing his mind about the mag ban. But guess what? The judge wasn't having any of it. It's like he put on his legal shades and said, "Sorry folks, the ruling stands." Yep, you heard it right. The judge gave the state's attempts to overturn the decision a big fat rejection. It's like trying to convince your teacher to change your grade after the report cards have been printed. Not happening. And what's the decision they're so desperately trying to reverse? Well, it's the one where the judge slammed the gavel down and declared the mag ban unconstitutional. That's like saying, "Hey, state, you can't just mess with people's mags like that. It's against the rules, the big important constitutional rules." The judge, standing firm like a legal rock star, said, "Nope, no turning back on this one." It's a bold move, considering the state probably brought out all the legal big guns to try and sway the decision. But this judge isn't budging, and the mag ban remains on the ropes. It's like a legal tug-of-war, and right now, the judge's side has got a pretty strong grip. The state might be waving their objections like flags, but the judge's stance is clear: the mag ban stays struck down. So what's the takeaway from this breaking news? Well, it's a victory for those who believe in the right to bear arms without unnecessary restrictions. The judge is holding the line against the state's attempts to rewrite the legal playbook, and the mag ban is still in the constitutional penalty box. Stay tuned for more twists and turns in this legal roller coaster. The judge has spoken, and for now, the mag ban is feeling the heat.
The previous ban on assault weapons. This has nothing to do with the Second Amendment.
The most popular handgun in the United States that was purchased is the Glock 19.
Gun Owners of America celebrates. Grab your party hat, folks, because the GOA just pulled off a legal victory dance that's got the whole Second Amendment community cheering. In the spotlight today is the Arnold versus Kotek lawsuit, and let me tell you, GOA is popping the champagne for a reason. Picture this: the courtroom filled with the tension of legal battles, and there's GOA strutting in, ready to take on the big guns. And boy, did they deliver. They weren't just players in this legal drama, they were the stars, the heroes, the ones fighting tooth and nail for our right to bear arms. So what's the scoop? GOA took center stage as the plaintiff in the Arnold versus Kotek lawsuit, gearing up for an epic showdown against the powers that be, particularly the infamous Measure 114. This measure, trying to play referee with our firearms and mags, found a formidable opponent in GOA. And guess what? GOA didn't just throw a legal jab or two, they landed a knockout punch. The court ruled in favor of GOA, declaring their legal challenge a success. It's like a victory lap for the defenders of the Second Amendment, and GOA is soaking in the applause. This isn't just about winning a lawsuit. It's about standing up against Measure 114, a regulation that aimed to put a damper on our right to own and use firearms. GOA stepped into the ring not just as a plaintiff, but as a champion for gun owners everywhere. They played a crucial role in opposing Measure 114, which wanted to throw hurdles in the path of law-abiding citizens looking to exercise their Second Amendment rights. It's like GOA raised the banner for all of us who believe in the fundamental right to bear arms without unnecessary restrictions. So, let's raise our glasses to GOA, the unsung heroes of the Arnold versus Kotek lawsuit. They fought the good fight, stood tall against Measure 114, and came out on top. It's not just a win for them, it's a win for every gun owner who values their rights. As the celebrations kick off, let's remember that GOA isn't just an organization, they're the defenders of our liberties, the ones who make sure our voices are heard in the legal arena.
You say that crime went down, but did you know that the sales of the so-called assault weapons went up?
The Second Amendment says the right to keep and bear arms shall not be infringed.
Measure 114 invalidated. Hold on to your holsters, Oregonians, because Measure 114 just got a reality check. It's been invalidated, and the Second Amendment enthusiasts are doing a victory dance. This measure, thinking it could waltz in and throw a wrench into firearm purchases, just hit a legal roadblock. So here's the deal. Measure 114 wanted to play the tough guy, slapping restrictions left and right on anyone wanting to snag a firearm. They had this grand plan involving purchase permits, safety training, background checks, basically turning the process into a bureaucratic obstacle course. But guess what? The court stepped in like a superhero, declaring Measure 114 null and void. It's like the judge said, "Hold on a second, you can't just make law-abiding citizens jump through hoops like circus animals." This means the requirements for a purchase permit, safety training, and background checks, all the red tape Measure 114 wanted to unroll, have been halted. No more having to prove you're a firearms expert just to exercise your Second Amendment rights. It's a win for common sense, a win for those who believe in the right to bear arms without unnecessary hurdles. The court basically said, you can play dictator with the Second Amendment, and Measure 114 got the boot. Imagine the collective sigh of relief from law-abiding citizens who are about to get tangled in a web of paperwork and prerequisites. The court's decision means freedom from the unnecessary hassle that Measure 114 was trying to impose. So to everyone who values their right to bear arms without feeling like they're applying for a NASA mission, this one's for you. Measure 114 tried to play sheriff, but the court said, not in our town. It's a reminder that in the great state of Oregon, the Second Amendment isn't just a suggestion, it's a right that won't be trampled on. So here's to the court for giving Measure 114 the legal equivalent of a "you're fired." It's a win for freedom, and that's always worth celebrating. Understanding Oregon's Measure 114. Let's dive into the nitty-gritty of Oregon's Measure 114. The good, the bad, and the downright unconstitutional. Buckle up, because we're about to unravel the elements that had legal scholars scratching their heads. Measure 114 was like Oregon's attempt at setting up a fortress of regulations around firearm ownership. But here's the catch. The court didn't buy it, and they called out the unconstitutional elements one by one. First on the list was the permit scheme. Measure 114 wanted to make obtaining a permit feel like you're applying for the Secret Service. Picture this: completing a safety training course, going through a background check, getting fingerprinted. It's like they wanted you to have a personal dossier just to exercise your Second Amendment rights. The court wasn't having any of it and said, hold on, you can't make law-abiding citizens jump through hoops like that. Then comes the background checks. Sure, they're a standard procedure, but Measure 114 wanted to crank it up a notch. They were turning it into a Hollywood-style investigation, complete with a dramatic soundtrack. But the court said enough is enough. They put a stop to the excessive background check requirements, reminding everyone that gun owners aren't automatic suspects. And let's not forget the mag capacity limitations. Measure 114 tried to play referee with how many rounds your mag could hold, but the court blew the whistle on that one. They said, you can't just slap restrictions on law-abiding citizens who want a few extra rounds for their firearms. In a nutshell, the court basically looked at Measure 114 and said, you're overstepping the constitutional boundaries. It's like they put on their legal glasses and saw through the smoke and mirrors of excessive regulations. So what's the takeaway? Measure 114 tried to make owning a firearm feel like navigating a maze of red tape. The court, however, stepped in to ensure that our Second Amendment rights aren't treated like a privilege with unreasonable conditions. Timeline of legal battle. All right, let's take a trip down the legal memory lane, tracing the epic saga of the Measure 114 legal battle in Oregon. This roller coaster ride has everything: drama, suspense, and a knockout punch in the form of a permanent injunction. Phase 1, the temporary restraining order. It all kicked off with the TRO. Picture this as the legal equivalent of slamming on the brakes to prevent a collision. The court said, "Hold up, Measure 114, you're not going anywhere just yet." This TRO put a temporary halt on the state's grand plans to roll out restrictions on firearm purchases and mag capacities. The gun owners got a brief sigh of relief. Phase 2, preliminary injunction drama. The drama continued with a preliminary injunction. This wasn't just a pause, it was more like hitting the pause button and then rewinding it a bit. The court said, let's take a closer look at this Measure 114 business. This injunction prevented the full force and effect of the mag ban and purchase restrictions, giving the court time to examine the case more thoroughly. Phase 3, the big ruling, permanent injunction. Then came the grand finale, the court's big ruling. Brace yourself, this was the moment that determined Measure 114's fate. The judge, after careful consideration, dropped the shocker, a permanent injunction. This wasn't just a temporary setback, it was a knockout blow. The court declared, Measure 114, you're not just paused, you're canceled. The unconstitutional elements were too glaring, and the judge made it clear. Oregon's attempt to restrict firearm purchases was a no-go. Timeline highlights. TRO put the brakes on. The court issues a TRO, temporarily stopping Measure 114 from going into full effect. Preliminary injunction. Drama unfolds. The court grants a preliminary injunction, preventing the mag ban and purchase restrictions from fully taking hold. The legal battle intensifies. The grand finale. Permanent injunction. The court delivers the ultimate verdict, a permanent injunction against Measure 114. The mag ban and purchase restrictions are officially struck down, sending shockwaves through the legal landscape. Judge ruling. The judge's ruling against Oregon's Measure 114 marked a pivotal moment in the legal battle, with profound implications for the state's firearm regulations. Striking a resounding blow for the Second Amendment, the judge's decision meticulously dismantled the constitutional arguments put forth by Measure 114. Measure 114's audacious attempt to implement a purchase permit scheme faced intense scrutiny. The judge, wielding the constitutional compass, deemed the scheme an overreach, requiring law-abiding citizens to navigate a labyrinth of safety training, background checks, and fingerprinting was declared inconsistent with the spirit of the Second Amendment. The measure's aspirations didn't end there. It sought to restrict mag capacities. The judge, a guardian of constitutional rights, dismantled this element, emphasizing that limiting access to mags for law-abiding citizens contradicted the fundamental principles of the Second Amendment. Central to the ruling was the safeguarding of the right to defend oneself and the state. The judge underscored the pivotal role of the Second Amendment in allowing individuals to lawfully possess firearms for self-defense. The ruling aimed to prevent undue burdens on gun owners, emphasizing the right to possess firearms as a crucial element in safeguarding against harm. The judge's analysis wasn't conducted in isolation. It was firmly grounded in the principles of the U.S. Constitution. The ruling echoed the constitutional tenets at the federal level, signaling that state measures attempting to infringe upon these rights would face rigorous scrutiny and, if found wanting, rejection. In essence, the judge's ruling was a resounding victory for those advocating the right to bear arms without unnecessary restrictions. It transcended the specifics of Measure 114, standing as a declaration that constitutional rights are sacrosanct. The decision serves as a powerful deterrent against attempts to curtail these rights, reaffirming that such endeavors will be met with unwavering legal scrutiny and, if deemed unconstitutional, resolute rejection.
The number of so-called assault rifles, what you all are calling assault rifles, had doubled.
In the Heller case, the Supreme Court made clear that the Second Amendment protects firearms in common use.
State's objections denied. In the aftermath of the court's decision, the state of Oregon fired off 7 objections in an attempt to salvage their anti-gun measures. It was a legal tug of war, and the state aimed to pull the decision in their favor. However, the judge, acting as the referee in this legal match, wasn't swayed by their arguments. The state's first objection played with the notion of timing, suggesting that the court's decision arrived too swiftly. They wanted more time to make their case, but the judge wasn't inclined to grant them an extension. Attempting to build a fortress around constitutional concerns, the state argued that the court's decision trampled on their constitutional rights. However, the judge, like a seasoned legal architect, dismantled this argument, leaving the state's fortress in ruins. Seeking a respite, the state requested a stay on the court's decision, essentially asking the judge to hit the brakes. But the judge, unmoved by their plea, denied the request, maintaining the momentum of the court's original decision. These legal maneuvers by the state were met with a resolute judge who rejected all 7 objections. It was a setback for Oregon's anti-gun measures, as the judge held the line against attempts to reverse or modify the court's decision. This legal clash underscored the challenges faced by those advocating for stringent gun control measures in the face of constitutional scrutiny. Next steps. In the aftermath of the judge's resounding rejection of the state of Oregon's objections to the court's decision on anti-gun measures, the legal battlefield is far from quiet. As the dust settles, attention turns to the potential next steps, including the likelihood of appeals and the broader implications for Second Amendment rights.
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
I'd also like to address the House on an issue that occurred yesterday in Maine. Another assault weapon.
States' potential appeals. In the legal tug-of-war between the state and defenders of Second Amendment rights, the state now stands at a crossroads. Facing a setback with the judge rejecting all 7 objections, the state is left with the option to appeal the decision. The prospect of such an appeal raises questions about the strategies and arguments the state might employ to overturn the court's rulings. The state could focus on refining their objections, addressing the judge's concerns, and potentially presenting new evidence to bolster their case. This could involve a careful examination of the legal nuances surrounding the purchase permit scheme, background checks, and limitations on mag capacities. However, the uphill battle becomes steeper considering the judge's firm stance on the unconstitutionality of these elements. The timing of potential appeals also adds a layer of complexity. With each passing day, the anti-gun measures remain halted, and the legal uncertainty persists. The state must weigh the costs, both in terms of time and resources, against the potential benefits of pursuing an appeal. Implications for Second Amendment rights. The legal skirmish in Oregon reverberates far beyond its borders, carrying implications for Second Amendment rights across the nation. The judge's steadfast defense of constitutional principles sends a powerful message that attempts to impose restrictive measures on lawful gun ownership will face rigorous scrutiny. The implications extend to the ongoing national debate on gun control. A favorable decision for Second Amendment advocates in Oregon could serve as a precedent, influencing legal battles in other states grappling with similar issues. Conversely, a successful appeal by the state might embolden other jurisdictions to push the boundaries of gun control measures. The heart of the matter lies in the interpretation and preservation of the Second Amendment. The court's decision to strike down anti-gun measures underscores the significance of protecting the right to bear arms without undue restrictions. It reinforces the notion that any attempts to curtail this fundamental right must align with constitutional principles.
For years, the Democrats told us we're not coming for your guns. Oh, yes, they are.
To a member on the Democratic side that served in a combat area designated zone and deployment of our country.
And they're coming for your firearms. 6 weeks ago, it was the red flag law.
Future course of the legal battle. Speculating on the future course of the legal battle involves navigating a landscape of uncertainties. The state, armed with the option to appeal, must weigh the potential outcomes against the costs and resources required. Advocates on both sides will closely monitor developments, anticipating the next legal moves and their potential ramifications. The legal battle in Oregon, with its twists and turns, serves as a microcosm of the broader national conversation on gun rights. As the legal drama unfolds, it provides a glimpse into the delicate balance between safeguarding public safety and preserving individual liberties. In the coming chapters of this legal saga, the courtroom will once again become the arena for debates on the scope and limits of the Second Amendment. Regardless of the ultimate outcome, the implications will resonate not only in Oregon but across the nation, shaping the contours of future discussions on the rights of citizens to bear arms. That's all for this video, folks. See you next time.